In today's video, we're going to drill down into two articles, one about regulation outside of the US for Ripple, and the other regarding the Hinman emails and what Ripple's attorney, Mr. Alderati, has to say about that. So here's our first article. Ripple welcomes MiCA regulation as US lawsuit highlights lack of clarity. Ripple's operations gear up in Europe and Asia despite an ongoing lawsuit with the U.S. Securities and Exchange Commission. Cryptocurrency payments service provider Ripple continues to see global adoption of its payment services, despite a long-winded legal battle with the United States Securities and Exchange Commission, SEC, over its XRP token. In a wide-ranging interview with Cointelegraph at Money 2020 in Amsterdam, Cindy Young, Ripple's managing director for Europe and the United Kingdom, unpacked the firm's growing remit worldwide despite ongoing regulatory scrutiny in the United States. Cryptocurrency exchanges and businesses have clashed with U.S. regulators over the past year, with a lack of regulatory clarity threatening to stifle innovation and adoption of blockchain-based services, systems, and cryptocurrencies. Meanwhile, the European Union is well on its way to instituting a set of requirements and standards for the cryptocurrency industry across the continent after the long-awaited Markets in Crypto Assets, or MiCA, legislation was signed into law on May 31st. The divergence of regulatory perspectives in the US and Europe is wide, Young told Cointelegraph, highlighting Ripple's business growth outside of the U.S., which is in part due to progressive regulatory oversight in different markets. That lawsuit is very isolated to U.S. regulations or the lack of clarity and certainty thereof. It almost accentuates the kind of environment that we have in Europe and the United Kingdom. Young added that Ripple continues to foster private-public partnerships and open dialogue with regulators and policymakers, with both parties educating each other as the industry develops. It does enable business to grow and innovation to happen. I would say we're very fortunate in this sort of UK-Europe environment, which is setting standards globally. In a European context, Young believes the MiCA regulatory framework will facilitate a level playing field that fosters healthy competition and innovation in the cryptocurrency space while driving adoption among traditional finance players. I think that's where we've seen much bigger mainstream take-up and the real benefits of crypto's utility being realized. Without clear regulation, that is impossible. I see that as the first step in getting more mainstream adoption. So I just want to pause there and say, I think that is a really important point that needs to be highlighted. You know, a lot of times people say, well, when is crypto really going to take off? When are prices going to take off? When moon, however you want to say it. And the reality is the first step in getting more mainstream adoption has to do with clear regulation. So that's why this Ripple case is so important, because we need that clarity. And once we have that clarity, whether we get it just for Ripple and XRP or whether we get it for the entire crypto industry remains to be seen. But if at a minimum we get it for Ripple and XRP, that may be the thing that we need for prices to really take off. The article goes on to say, Young highlighted Ripple's expanding basket of services aimed at plugging into an increasingly interconnected financial ecosystem. This is in part facilitated by crucial fiat on-ramps and off-ramps, as well as the development of central bank digital currencies and stablecoins. It's really a number of different currencies and CBDCs. They're all going to be coexisting, and that kind of ability to interoperate, to go in and out, is going to be very important. Ripple's ongoing lawsuit with the SEC took an interesting turn in June 2023 as eagerly awaited documents relating to a speech from former SEC Corporate Finance Division Director Bill Hinman highlighted contradictory viewpoints on classifying cryptocurrencies as securities. End of article. So we're going to continue that topic over in this article, also from Cointelegraph, that says Ripple's Alderati calls for probe into Bill Hinman and his infamous speech. Stuart Alderati is joined by a number of other high-profile individuals calling for an investigation into the former Securities and Exchange Commission official. Ripple's chief legal officer has called for an investigation into the motivations that led to former Securities and Exchange official William Hinman delivering his now infamous speech in 2018. Stuart Alderati's demand for an investigation came as part of a June 13th Twitter thread following the public release of the Hinman documents. The documents revealed that the Hinman speech was delivered despite warnings from other SEC divisions. And here's Stuart Alderati's tweet. He says, "So what should happen now? First, remove the speech immediately from the SEC's website." Well, I definitely concur with that. And he also says an investigation must be conducted to understand what or who influenced Hinman, why conflicts, or at the very least appearances of conflicts, were ignored, and why the SEC touted the speech knowing that it would create greater confusion. Yeah, for the SEC, who's supposed to protect consumers, and for them to create confusion intentionally is ridiculous. The other thing we need to know is who were the whales? Who were the people that invested in Ethereum that Bill Hinman gave the free pass to that benefited dramatically as the price of Ethereum rose right after his speech? So in my opinion, that was all planned, and there was some group of individuals in on it. After all, Hinman didn't write his own speech. The venture capitalists wrote the speech for Bill Hinman. They said that they did. So it's ridiculous to have someone else write the speech for someone in the SEC that creates more confusion in the industry. There's something very wrong. This article goes on to say, in the 2018 speech, Hinman asserted that Ethereum is not a security as a result of it becoming sufficiently decentralized, before elaborating on what factors must be satisfied when making that determination. Alderati argued that, according to the newly released documents, Hinman had ignored the warnings of other SEC officials, suggesting his speech contained made-up analysis with no basis in law, and that the speech ended up sending confusing messages to the cryptocurrency industry regarding what constitutes a security. Well, that's exactly right. There is no, quote, sufficiently decentralized definition. That was his own making, and by throwing that terminology out there, he was essentially making up his own law, and that's ridiculous. Alderati said that unelected bureaucrats should only apply the law rather than trying to create new ones, and added that Hinman's speech should never again be invoked in any serious discussion about whether a token is or is not a security. Ripple CEO Brad Garlinghouse joined Alderati in his criticism of the regulator in a June 13 Twitter thread, arguing that the decision to go ahead with the speech, despite so much pushback, was unconscionable. Brad says it's absolutely unconscionable that a regulator, when presented with so much pushback on what he was about to say, / how he compiled his fake test in the first place, decided to move forward anyway and throw an entire industry into chaos. Yeah, I agree with that. Speaking with Cointelegraph, pro-XRP lawyer and crypto law founder John Deaton noted that he also believes an investigation is warranted, adding that the fact that Hinman had referred to the speech as an ether speech raised questions about what motivated the speech. Deaton and Alderati's comments on Hinman's motivations seem to reference Hinman's alleged ties to the Enterprise Ethereum Alliance, an advocacy organization that seeks to drive the use of Ethereum blockchain technology. Before and after working with the SEC, Hinman worked at the law firm Simpson Thacher and Bartlett LLC, which was a member of the Ethereum Enterprise Alliance. Yeah, and we know he got a big paycheck also. End of article. So very interesting. I think more is to come from these Hinman emails. I do hope we can get an inspector general to take a closer look. This needs to be investigated. We need to know who those whales were and who was involved in investing in Ethereum while this whole scheme was put into place that cleared Ethereum as not being a security and allowed its price to rise dramatically. So there's some shady stuff here. We need to get to the bottom of it. That's all for today. Until next time, live the good life and be wealthy and smart.